Hi, everybody. Danny Taylor here from the YOLO Home team. And I am so excited today to have a little chit chat with Shari Sugarman from Sugarman Law in Deer Park. Correct? Deer Park, right? Is that where
Correct,
we are?
Deer Park.
Great.
Yes.
Wonderful. So, Shari, I don't know if you're aware, but the YOLO Home team supports a local non-for-profit. It's a charity that I created 12 years ago. And traditionally, we had raised funds. We raced to raise funds for medically fragile and terminally ill children. And then we created this real estate team. So every time we buy or sell a home, we donate a portion of the proceeds to the non for profit and we help a local family who has a medically fragile or terminally ill child. So
Oh,
we
that's
really,
wonderful.
oh, thank you. So we really appreciate you coming and kind of like adding some color to how estate and real estate cross cross over each other and how they impact each other. Let's kind of just go through, I guess, just an overall or a quick question, introductory question. So, how would you say that property trust factor into estate planning, and how can it benefit your clients?
There's two types of trust. There's one that people in older usually use. It's an irrevocable trust. That's where you have somebody else who's the trustee, and we make the owner of the house pour on paper so that if they go into a Medicaid assisted supported living facility in 5 years or more, then there shouldn't be any Medicaid liens. The second type of trust is a revocable trust. That doesn't protect people from creditors, but it does make it easy to sell the house once the grantor, the owner of the house, has passed. Basically, what happens when somebody passes away and an estate has to sell the property, you have to probate. Either you have a will or you don't, but it's still you still have to put in a petition to the court and have somebody appointed. That can take several months. That's going to cost a lot of money. It could cost anywhere, well, if your assets are more than $500,000, which most houses are, your minimum fee for the filing fee to the court is $1,250. So then the attorney is going to charge you $2,500 to $5,000, depending on the complexity of the estate, just to put that petition in, and it could take several months. And then you have to worry about creditors to the estate that come out of the woodwork. They've got 9 months. So with either trust, it is really very simple to sell the property. The trustee has the ability and the authority to sell that property at any time. Otherwise, you have to wait for somebody to be appointed, and then you have to wait for, estate tax issues and this, that, and the other thing. It could take a long time.
Okay, and so I guess I was actually going to ask you about revocable and irrevocable trust. That was going to be my next question, so you actually covered it. But so in what case would you recommend a revocable as opposed to an irrevocable trust? Because this question actually hits home for me. So my
Mm.
dad passed, and the house is in an irrevocable trust, and I'm the guarantor or guarantee.
No, you're either the trustee
So I'd
or
be
the
the
beneficiary,
So I'd
or
be
you could
the,
be both, actually.
yeah, I'm both, on my dad's house. So at what, I guess, in what instance would you recommend one as opposed to the other?
Well, it's all about control and what your real aim is for estate planning. If you are looking to preserve your assets from any Medicaid liens, and someday you might have to go into a nursing home, then an irrevocable trust is the best because, like I said, we make you pour on paper so that you have no control over your assets, and therefore Medicaid can't claw it back. With an revocable trust, you have control. So if you wanted to put your house into a trust and be the trustee, you still have control. Um, you can you can borrow money. With an irrevocable trust, you cannot. And a lot of times, people with assets in different houses in different states would like to have a revocable trust. A lot of times, they are in their 50s and they don't want to give up control.
Yeah.
Um, that's the key point, giving up control.
Okay. I
And, if somebody's got, oh, say I'm working on an estate right now. It's not an estate, it's an estate plan where a gentleman has several businesses and we're going to be doing a revocable trust so that he still has control over those businesses as well.
understood. So that was really, really helpful. Let me ask you another question. What are some common mistakes that you're finding with people who have a will in place? But what are some of the shortfalls that you're finding?
Well, a lot of times, and it's recently happened over the last couple of years, I've had several instances where mom and dad thought, hey, I have three kids, I'm going to give it to equally to all three children. Meanwhile, one of the children has sold their house and moved in with the father or the mother, the remaining parent, to take care of them,
Yeah.
and they don't have any place to live when mom or dad dies. So the other two siblings will come in and say, "Hey, let's sell the house where I'll give you your share." And the remaining sibling who has given up everything now is faced with, oh, okay, well, it's a $500,000 house. I'm going to get maybe $150,000. That's not enough to buy me a house. What am I going to do? So unintended consequences are what I see in mistakes of drafting. I had an older lady pass away just recently, and she was a bit of a recluse. She only had a few friends. She had family, but she didn't keep in touch with them. Um, the attorney who drafted it, you get what you pay for, I guess. Didn't charge her very much, but insisted that in order to, you know, not have one of her family members uh, contest the will, then we put him in for $100. Well, now we have to go spend more than $100 serving him with a citation and other things. When he was only a nephew, he wasn't even entitled to a share of the estate. So that was an unintended consequence. She's like, "Oh yeah, I'll just do it. I'll do it." And the page and it wasn't even stapled. The will wasn't stapled. It was just poorly done. So,
So it,
you see little things like that.
it's interesting that you raised that situation with the homeowner that passed because I actually had a situation where I was selling a home and the owner had passed away and the executor of the will was out of state, but there were three other siblings, one of which lived with the mother. And so I was actually quite grateful for how everyone was respectful of each other. And um, there was no underhandedness. Everyone just wanted everyone to be comfortable, even as far as like when I was selling the home, they said, we want to make sure that she has enough time to gather her belongings. We don't want her to feel rushed. It's all about what time frame works for her. But given other situations, and we know that when people pass away that we care for, it's a very emotional situation. Um, you know,
Very much so.
people can handle it very differently. So it's really, and I actually thought, wow, this could have been a much different outcome if people weren't
Yes.
so compassionate over each other's feelings.
Yeah, I had that
Uh,
actually happen twice right about the same time. One of them, she was still working, so she was able to buy her brothers out. And another one, he was in his 70s and he didn't have any income. So we arranged for a reverse mortgage so he could buy his sibling out. I mean, he had
wow.
literally lived there his entire life.
Wow. I actually do have a question though. Back to your example regarding the revocable and irrevocable trust. So let's say there was a home and it was in an irrevocable trust, and the trustee decided that they wanted to keep it. Is that the situation where you were referring to? Where it could be time consuming and could take a lot of time to settle.
The powers that are listed in authority of the trustee is in the trust document. It's usually they refer to the law, the surrogates procedure law, and the New York state law regarding the authority, but sometimes they grant them additional. If it is a rental, they can keep it. And they can, as long as they're prudently acting on behalf of the beneficiaries, they can do that.
Yeah.
So, for example, you are the trustee and you are the beneficiary. If you decide that you want to rent that house rather and keep it in the estate, then that's up to you. It's up to what your plan is.
Okay.
Um, I will caution, however, because you will get a date of death value on the house, and if you keep it for 10 years, the either the trust or you will have capital gains.
Yep. Yep.
Yeah.
Yes.
So that's something that you have, one has to consider when they, are going to sell the house, rent the house. And if it's in the trust, you may have to pay. I am not an accountant. I do not give tax
Yeah, of
advice, but
course.
you may have to pay income tax on the
Yep.
trust rate and not the personal rate. So
Um,
there are benefits for it, and there's, things for and against it.
I think it's really it's just important that I think sometimes people don't know what they don't know, right? So that's where
Very
people like
much.
you come into effect where, it can all of the knowledge that you have, weighing the pros and cons will allow someone to make the best choice for them to move forward. Um, and I guess another question I have is like, what are some legal protections that you can recommend for surviving spouses in real estate? So, we see a lot of times, unfortunately, loved ones pass away. And so, what are some legal protections that you can recommend?
Well, I'm going to talk in generalities and not second families and things like that. But one of the biggest mistakes I see is that sometimes somebody buys a house and they don't put their spouse on it because of many reasons. Sometimes they are the better one with the credit, the other one doesn't have income, has terrible credit, etc. There's a lot of reasons why, but then they should go and do a deed transfer shortly thereafter in order to put both of them on the house. I had a situation back in early COVID where the wife was not on the deed. She had a 17, 18-year-old son, and the husband passed away. Well, legally, now he didn't have a will. So it went by the intestacy laws. That means without a will. And so the way it goes is if somebody has a spouse and no children, the spouse gets it all. If they have children and no spouse, it goes to the children. But if they have a spouse and children, the spouse gets one half plus the first 50,000, and the children get the rest.
Oh, wow.
So now she is now the owner of this house with her child,
Children,
who's
yeah.
18 and who is mad at her for various reasons, and is, even though they're both responsible for the expenses of the estate because they're the both owners, can't do anything.
And so this
So go ahead.
I was just going to ask, let's just say that there's a situation whereby, and it probably happens a lot, people get divorced, unfortunately, but let's say in that threshold of time where, you have X amount of time where one spouse can stay in the house, they're going to split the house 50-50, but let's just say during that time period, one of the spouses pass. How does that work? Do any of those situations change?
They're getting a divorce, you mean?
Yes. So they're getting a
Ah,
divorce, and the house, let's say, is, the one of the spouses can stay in for, 5-7 years. But in between that time, one of the spouses passed away, right? So now what
now
happens?
if they're divorced, it depends on the terms of the agreement.
Mhm.
Most family lawyers will draft a very good agreement addressing all the unintended consequences.
Yeah.
And that's really what lawyers are about, is re spotting the issues and trying to resolve them before they become a problem.
Yeah.
So if they are in a separation agreement or if they are already divorced, what will happen is if they're husband and wife, well, let me take back a step. There's three ways of holding property. One is joint tenants with rights to survivorship. That means if you and I own a house together, joint tenants, I die, it goes to you, you die, it goes to me.
Yeah.
Uh, there's tenants in common. Again, same scenario. You die, it goes to your heirs. I die, it goes to my heirs. And then we have tenants by the entirety, which is strictly for husband and wife, but works like joint tenants. So if you have the deed, Joe Smith and Mary Smith own the property as husband and wife, as long as they're husband and wife, it's joint tenants.
Right.
But if they get divorced, then it becomes tenants in common. So they could still split it.
Oh, wow, wow.
Yeah, there's
So
a lot to know.
yeah, I mean, this is really exciting. I would love it if maybe sometime after the new year, you and I could sit down and maybe have a little bit more in-depth conversation about estate and property, and maybe even some of the new laws that have come out that, are really maybe confusing people, and we could just have like a longer chat. Maybe you'd be up for that. I would really appreciate that. I think all of
I
my
would love to.
that'd be great. Well,
Yeah,
look,
there are there are two just real quick. There are two things that just came down this last year. One's called a transfer on death deed,
mhm.
which can transfer a house to a beneficiary, and then the other one, as a realtor, the real property disclosure statement.
Yes,
That has thrown everybody for a loop because then we don't know exactly who's supposed to fill it out. What kind of advice we're supposed to give. We just know that we have to give it to the other side. It's very confusing. So
estate
I would
sales.
love to give you an update.
Yeah, that would be great. I would love that. Estate sales happen to be one of those situations where the property disclosure statement doesn't need to be completed or shared.
Correct.
So it's
That
very,
and
very
trust.
interesting. Yeah.
That
So
and trust, because typically you would think that the trustee or the fiduciary doesn't have personal knowledge of the house. So think of it
exactly.
that way.
Well, look, Shari, thank you, thank you, thank you. I really appreciate your time. I know that you're a busy lady, and I would really do look forward to us sitting down and chatting a little bit more in depth after the new year.
I do too. Have a wonderful holiday. Thank you for having me on your little podcast. I
Of
appreciate it.
course. We all really
And
appreciate you, and we'll speak soon.
absolutely. Thank
Thank
you.
you.